I never imagined that a quiet Tuesday morning would turn into a 3-year legal nightmare that would expose corruption, forgery, and a conspiracy that reached all the way to the county clerk's office. But when I stepped outside to get my mail and found a massive chain blocking the entrance to Riverside Lane, I knew my peaceful life in Cedar Springs, Arizona, was about to explode into chaos. My name is Xavier, and I had lived at 1247 Riverside Lane for 8 years. The street was a beautiful private road lined with mature oak trees, connecting 6 homes to the main highway. When I purchased my property back in 2018, the title clearly stated that Riverside Lane was a private road maintained by the residents through a voluntary maintenance agreement. We all chipped in about $300 a year to keep it paved and clean. It was simple, straightforward, and worked perfectly for everyone involved. That morning in March 2023, I stared at the heavy-duty chain stretched across the entrance with a hand-painted sign dangling from it that read, "Private property, no trespassing, violators will be prosecuted." My coffee mug nearly slipped from my hand. I lived on this road. How was I supposed to get to work? I pulled out my phone and called my neighbor, Tom Henderson, who lived 2 houses down. "Tom, are you seeing this?" "I am looking at it right now from my driveway," he said, his voice tight with anger. "I called the police already. They are sending someone out." Within 20 minutes, 4 of the 6 homeowners on Riverside Lane stood at the chain, along with Officer Martinez from the Cedar Springs Police Department. The officer examined the sign and looked at us with a mixture of confusion and sympathy. "Who put this up?" Officer Martinez asked. "That is what we would like to know," said Patricia Chen, who lived in the house closest to the highway. "This is our road. We all have easement rights." As if summoned by our collective frustration, a silver Lexus pulled up on the other side of the chain. Out stepped a woman in her early 50s with perfectly styled blonde hair, designer sunglasses, and an expression that screamed entitlement. She wore a cream-colored pantsuit that probably cost more than my monthly mortgage payment. "Can I help you people?" she asked, her voice dripping with condescension. "You can start by explaining why you have blocked access to our homes," I said, trying to keep my voice level. She removed her sunglasses and looked at me like I was something stuck to the bottom of her expensive shoes. "I am Karen Whitmore, president of the Sunset Ridge Homeowners Association, and this road is part of our development. You people have been trespassing on HOA property for years, and we are done tolerating it." I felt my blood pressure spike. Sunset Ridge is on the other side of the highway. Riverside Lane has nothing to do with your HOA. Karen pulled out a folder from her car and walked up to the chain, waving some papers at us. "According to the county records I obtained last week, this road was deeded to the Sunset Ridge HOA in 2005 as part of our development agreement. You people do not have any legal right to use it." Officer Martinez stepped forward. "Madam, these residents have property access issues. You cannot just block a road without proper legal procedure." "I have every legal right," Karen snapped. "This is private HOA property, and these trespassers need to find another way to access their homes. Perhaps they should have done their due diligence before purchasing property on someone else's land." Tom's face turned red. "This is insane. I have lived here for 15 years. This road was here before your HOA even existed." "Take it up with a lawyer," Karen said, putting her sunglasses back on. "The chain stays up. If any of you cross onto HOA property, I will have you arrested for trespassing." She turned to Officer Martinez. "Officer, I expect you to enforce the law." Officer Martinez looked extremely uncomfortable. "Madam, sir, this appears to be a civil property dispute. I cannot force anyone to remove the chain without a court order, but I also cannot prevent these residents from accessing their homes. My suggestion is that you all seek legal counsel immediately." Karen smiled triumphantly and got back into her Lexus. "Good luck finding another way home," she called out before driving away. We stood there in stunned silence. Officer Martinez took down all of our information and the details of the incident, then suggested we contact the county assessor's office to pull our property records. After he left, we had an emergency meeting right there on the side of the highway. "This is absolutely ridiculous," Patricia said. "We all have title insurance. There is no way this woman has a legitimate claim to our road." "She seemed pretty confident," Tom said, looking worried. "What if she is right? What if there was some mistake in our deeds?" "Then we fight it," I said firmly. "But first, we need to understand exactly what we are dealing with. Patricia, you are a paralegal, right? Can you help us pull the records?" She nodded. "I will go to the county recorder's office this afternoon. We need to see the actual deeds and any documents this woman is claiming gives her HOA ownership of our road." Since we all needed to get to work and had no intention of letting Karen Whitmore dictate our lives, Tom went to his garage and came back with bolt cutters. "I am not letting some HOA tyrant trap us on our own property," he declared. He cut the chain, and we all drove out. I had a feeling this was just the beginning of our problems. That afternoon, I took a half-day from my job as an IT consultant and met Patricia at the Maricopa County Recorder's office in downtown Cedar Springs. The building was an old Spanish-style structure with terracotta roof tiles and thick adobe walls that kept it cool even in the Arizona heat. We spent 3 hours going through records with the help of a clerk named Denise, who seemed genuinely interested in our bizarre situation. Patricia had brought all of our property deeds, and we requested every document related to Riverside Lane dating back to 1990. What we discovered was both reassuring and deeply confusing. Our property deeds all clearly showed easement rights to Riverside Lane, described as a private road maintained by the property owners. The road had been created in 1995 when a developer named Frank Morrison subdivided a large parcel of land into 6 residential lots. The road was never intended to be public, but it was also never part of any HOA. "Here is where it gets interesting," Patricia said, pointing to a document from 2005. "This is the filing for the Sunset Ridge development. They are on the other side of Highway 87, completely separate from our properties." Denise, the clerk, pulled up a map on her computer. "Yeah, Riverside Lane is parcel 445-67-890. Sunset Ridge HOA is parcels 445-7100 through 445-7250. Completely different sections." "So Karen was lying," I said. "She has no claim to our road." "Hold on," Patricia said, her brow furrowed. She was looking at another document. "There is something filed here from 2022, last year. It is a correction deed claiming that Riverside Lane was mistakenly omitted from the original Sunset Ridge HOA plat, and that this corrects the error." My stomach dropped. "Who filed that?" Patricia examined the document closely. "It is signed by someone named Margaret Peterson as HOA president, and it is notarized. But look at this. The original document it claims to correct is from 2005, but that original document does not mention Riverside Lane at all. You cannot correct an omission that was never an error in the first place." Denise leaned over to look. "That is weird. Who accepted this filing? Every correction deed needs to reference the specific error being corrected. This looks like someone just tried to claim a new piece of property through a backdoor filing." "Is that legal?" I asked. "Absolutely not," Denise said. "But if no one challenges it, it stays on the books," Give me a minute." She disappeared into a back office and returned 15 minutes later with an older man who introduced himself as Robert Finch, the chief deputy recorder. "Denise showed me what you found," he said, settling into a chair with a heavy sigh. "I remember this filing." The woman who submitted it was very insistent. Karen Whitmore. She claimed it was urgent and threw a fit when I told her it needed additional documentation. She ended up going over my head to my supervisor. "Who approved it?" Patricia asked. "Gary Mitchell, our elected county recorder." He overrode my concerns and accepted the filing. Robert looked distinctly uncomfortable. "Between you and me, Gary and the Sunset Ridge HOA have a relationship. His wife is on the HOA board." "That sounds like a conflict of interest," I said. "It absolutely is," Robert agreed. "But unless someone officially challenges the document, there is not much I can do about it. You folks need to file a quiet title action. That is a lawsuit that asks the court to determine who actually owns the property rights." Patricia was already taking notes. "We will need a real estate attorney. A good one." We left the recorder's office with copies of every relevant document. That evening, all 6 families on Riverside Lane met at my house. I had a large living room that could accommodate everyone, and my wife Nina had graciously offered to make coffee and set out snacks before she left to visit her sister for the evening. Tom Henderson was there with his wife Judy. Patricia Chen came with her husband Marcus. The Kowalskis, an elderly couple named Eugene and Dorothy, arrived with their daughter helping them. And finally, there were the Johnsons, Melissa and Craig, who had moved in just last year with their twin toddlers. I spread all the documents out on my dining room table and explained what Patricia and I had discovered. The room fell silent as everyone absorbed the implications. "So this woman just decided to steal our road," Judy Henderson said finally. "How is that even possible?" "It should not be," Patricia said. "But she exploited her connection to the county recorder and filed a fraudulent correction deed. Now it is on the official records, which gives her a paper claim even though it is completely bogus." "What do we do?" Melissa Johnson asked. She looked exhausted, and I remembered that her twins were going through a sleep regression. "We cannot afford a big legal battle. We just bought our house." "None of us can afford this," Eugene Kowalski said. His hands trembled slightly as he reached for his water glass. "Dorothy and I are on a fixed income. We were planning to retire here peacefully." "We fight it together," I said firmly. "We split the legal costs 6 ways, and we make sure everyone knows what the Sunset Ridge HOA is trying to do. This is not just about property rights anymore. This is fraud." Tom nodded. "Derek is right. If we let them get away with this, what is next? They claim our houses were supposed to be part of their HOA too." "I know a real estate attorney," Marcus Chen offered. "Her name is Natalie Griffin. She handled our house purchase and she is tough. Let me reach out to her tomorrow and see if she will take our case." We all agreed. Each family committed to putting in an initial retainer of $2,000, which we hoped would be enough to get the legal process started. As everyone left that night, I felt a strange mixture of anger and determination. Karen Whitmore had picked the wrong people to mess with. The next morning, the chain was back up across Riverside Lane. This time it was secured with a heavy-duty padlock. Tom cut it again, and we all documented everything with photos and videos. We were not going to let the HOA hold us hostage. 2 days later, Patricia called me with news. "Natalie will take our case. She reviewed all the documents and she is absolutely furious. She said this is one of the most blatant cases of property theft she has ever seen. She is filing the quiet title action today, and she is also reporting the fraudulent filing to the state bar and the county attorney's office." "That is great news," I said, feeling a rush of relief. What happens next? We have to serve the HOA with the lawsuit, and then we go through discovery. Natalie thinks this could take anywhere from 6 months to 2 years depending on how much the HOA fights it, but she is confident we will win. 2 years, I repeated, my heart sinking. We have to deal with this for 2 years. Maybe less if they realize their case is hopeless and settle, but Karen Whitmore does not strike me as the type to give up easily. Patricia was right about that. Over the next week, the situation escalated dramatically. The HOA did not just replace the chain when we cut it. They installed a full gate with a card reader and a camera. They had done it overnight, working with a construction crew that must have cost tens of thousands of dollars. On Monday morning, I drove up to find the gate completely blocking the road. There was an intercom system with a call button. I pressed it, and after a long wait, Karen's voice crackled through the speaker. "Can I help you?" "You can open this gate so I can get to my house," I said, trying to keep my temper in check. "You have an access card." "You know I do not have an access card. I live on this road. You are blocking legal access to my property." "Then I suggest you contact your attorney." The intercom clicked off. I called Tom, Patricia, and the others. We all converged on the gate within 30 minutes. Craig Johnson was livid, shouting at the camera that they had a family emergency and needed to get home. The intercom remained silent. "That is it," Tom said. "I am ramming this gate." "Do not," Patricia warned. "That is destruction of property. She will have you arrested. Call the police again." We called the Cedar Springs Police Department, and this time Officer Martinez arrived with his sergeant, a weary-looking woman named Sergeant Foster. She examined the gate and listened to our explanation. "This is the same property dispute from last week?" she asked. "Yes, but now they have installed a gate that prevents us from accessing our homes," I explained. "We have a lawsuit filed. Our attorney sent them a cease and desist letter." "They are ignoring all of it." Sergeant Foster sighed and walked up to the intercom. She pressed the button and identified herself. After a moment, Karen's voice came through, much more polite than it had been with me. "Good morning, Sergeant. How can I help you?" "Madam, I need you to open this gate. These residents need access to their properties." "Sergeant, this is private HOA property. These individuals are trespassers. I have documentation proving ownership." "Madam, they also have documentation proving they have legal easement rights." "This is a civil matter that needs to be resolved in court, but in the meantime, you cannot prevent people from accessing their homes. That is illegal." "I disagree with your interpretation, Sergeant. I will not be opening the gate." Sergeant Foster's jaw tightened. "Madam, if you do not open this gate, I will have to consider this unlawful restraint and false imprisonment. You are holding people hostage on their own property." There was a long pause. Then, finally, the gate began to swing open. We all drove through quickly, but I noticed the gate closing immediately after the last car passed. That afternoon, Natalie Griffin filed an emergency motion for a temporary restraining order and preliminary injunction. She argued that the HOA's actions constituted an unlawful taking of property rights, and that they were causing immediate and irreparable harm to her clients. The hearing was scheduled for the following week in Maricopa County Superior Court. I had never been involved in a lawsuit before, and the stress was taking its toll. I was not sleeping well, constantly worried about what Karen and her HOA would do next. Nina tried to be supportive, but even she was getting frustrated with the situation. "Maybe we should just sell and move," she suggested one night after I had spent 3 hours going over legal documents instead of watching a movie with her. "And let them win," I said. "No way. Besides, Who would buy a house on a street where some crazy HOA can block access whenever they feel like it? She did not have an answer for that. The truth was, our property values had effectively plummeted the moment Karen put up that first chain. If we did not fight this, we would lose everything. The restraining order hearing was held on a Thursday morning. All 6 families showed up for support, packing the small courtroom. Judge Harold Preston presided, a stern-looking man in his 60s with silver hair and reading glasses perched on his nose. Natalie presented our case with precision and passion. She showed the judge our property deeds, the original plat maps, and the fraudulent correction deed filed by the HOA. She brought in Denise from the county recorder's office as a witness, who testified that the correction deed did not meet the legal requirements for such a filing. The HOA was represented by a lawyer named Richard Stokes, a slick-looking man in an expensive suit who spoke in a condescending tone that immediately rubbed me the wrong way. He argued that the HOA had a legitimate claim to the property based on the 2022 correction deed, and that the residents of Riverside Lane were the ones who had been trespassing on HOA property for years. Judge Preston listened to both sides, occasionally asking pointed questions. When Stokes claimed that the correction deed was valid, the judge interrupted him. "Counselor, a correction deed must reference a specific error in an original document. The 2005 plat for Sunset Ridge makes no mention of Riverside Lane whatsoever. How can you correct an omission that never existed?" Stokes fumbled for a response. "Your Honor, the omission was the failure to include language that Riverside Lane was part of the development. This was always the intent of the original developer. You have any evidence of this intent? Any documents, communications, or testimony from the original developer?" "Not at this time, Your Honor, but we are working to obtain such evidence." Judge Preston removed his glasses and rubbed his eyes. "This sounds like you are making a claim without any factual basis." The court will grant the temporary restraining order. The Sunset Ridge Homeowners Association is hereby ordered to cease and desist from blocking access to Riverside Lane. The gate must remain open at all times pending the resolution of the underlying quiet title action. Violation of this order will result in contempt of court charges. We had won the first battle. As we left the courtroom, I saw Karen Whitmore standing in the hallway with Richard Stokes, her face twisted in fury. She pointed at me and mouthed something I could not hear, but her expression made it clear that she considered this far from over. For a few weeks, things were relatively quiet. The gate remained open and we could come and go freely. The HOA still maintained the gate was their property and kept the cameras running, but at least we were not being held hostage anymore. Natalie warned us not to get too comfortable. "Discovery is about to start," she explained during a meeting at her office. "The HOA is going to request all of your documents, and we are going to request all of theirs. That is when we will really learn what they are basing their claim on." "Do you think they actually have something?" Tom asked. "Some document we do not know about." "I doubt it," Natalie said. "But we need to be thorough. I am also going to depose Karen Whitmore, the HOA board members, and the county recorder Gary Mitchell. I want to know exactly how that correction deed got filed and who was involved." The discovery process was exhausting and invasive. The HOA's attorney requested copies of our property deeds, title insurance policies, mortgage documents, and even our personal financial records. Natalie fought to limit the scope, but we still had to produce boxes of documents. In return, we received the HOA's discovery responses, and that was when things got really interesting. Buried in hundreds of pages of HOA meeting minutes and financial records, Patricia found something explosive. "Derek, you need to see this," she said, calling me late one evening. I have been going through the HOA meeting minutes from 2021 and 2022. In August 2021, there is a discussion about expanding the HOA's property boundaries. Karen proposed acquiring Riverside Lane to create a secondary entrance to their development. Why would they need a secondary entrance? I asked. They do not. But here is the kicker. The meeting minutes show that the HOA board voted down the proposal. They said it was too expensive and legally questionable. Karen was furious, according to the secretary's notes. She said she would find a way to do it anyway. So she went rogue and filed the fraudulent correction deed on her own. It looks that way. And there is more. I found records of payments to Gary Mitchell's wife, Susan Mitchell. The HOA paid her $25,000 in 2022 as a consultant fee for administrative services. I felt a chill run down my spine. That is a bribe. It looks like it, Patricia agreed. I am sending all of this to Natalie right now. Natalie was as stunned as we were when she reviewed the documents. This is potentially criminal, she said during an emergency conference call with all of us. If Karen Whitmore filed that correction deed knowing it was fraudulent, and if Gary Mitchell accepted it in exchange for payments to his wife, we are talking about fraud, bribery, and corruption of public office. What do we do? I asked. I am contacting the Maricopa County Attorney's Office and the Arizona Attorney General. This is beyond a civil property dispute now. This is a criminal matter. The following week, Natalie deposed Karen Whitmore. I was not allowed to attend, but Natalie provided us with a summary afterward, and she had also managed to record it per standard legal procedure. Karen had been evasive and hostile throughout the deposition. When asked about the correction deed, she claimed it was a legitimate filing based on advice from the HOA's attorney at the time, a man named Stephen Crawford who had since retired and moved to Florida. When asked about the payments to Susan Mitchell, she insisted they were for legitimate consulting services related to HOA administration. What kind of consulting services? Natalie had pressed. Susan helped us streamline our filing processes and improve our record keeping, Karen responded. Did she have any qualifications for this work? Any background in HOA management or administration? She had experience as a volunteer at the county recorder's office. So you paid her $25,000 for advice on filing documents with the office where her husband works as the elected county recorder. And then shortly after, your correction deed was accepted despite being flagged as problematic by the chief deputy recorder. Do you see how that looks? I see how you are trying to twist innocent business dealings into something nefarious, Karen had snapped. We did nothing wrong. That road belongs to our HOA, and you people are the ones who have been trespassing. The deposition of Gary Mitchell was even more illuminating. He was clearly nervous and kept referring to his attorney before answering questions. When confronted with Robert Finch's statement that he had overridden concerns about the correction deed, Gary claimed he had reviewed the document and found it to be in order. Did you investigate whether the correction deed was accurate? Natalie asked. I relied on the representations made by the filer. Did you disclose to anyone that your wife had received $25,000 from the same HOA that was filing this document? My wife's business dealings have nothing to do with my duties as county recorder. Did you disclose the payment? A long pause. I was not required to disclose it. But did you disclose it? No. By January 2024, the case had grown far beyond a simple property dispute. The Arizona Attorney General's office opened an investigation into Gary Mitchell for corruption and conflict of interest. The county attorney was investigating Karen Whitmore and the Sunset Ridge HOA for fraud and filing false documents. Our quiet title action was still pending, but Natalie was confident that, with the criminal investigations underway, the HOA would be forced to back down. She was wrong. In February 2024, Richard Stokes filed a motion claiming that the criminal investigations were prejudicing the civil case and requesting that our lawsuit be stayed until the criminal matters were resolved. Judge Preston denied the motion, but the HOA's aggressive tactics continued. They filed counterclaims against each of us individually, alleging that we had damaged HOA property by repeatedly cutting their chains and locks. They sought damages of $50,000 per household, plus attorney's fees. It was clearly an intimidation tactic, but it was effective. Eugene and Dorothy Kowalski were terrified. "We cannot afford this," Dorothy told me, tears streaming down her face. We were meeting at my house again, and the stress was visible on everyone's faces. "We have already spent $8,000 on legal fees. If we have to defend against their counterclaims too, it will bankrupt us." "Natalie says the counterclaims are frivolous," I said, trying to sound reassuring. "She is filing a motion to dismiss them." "But what if she is wrong?" Eugene said. "What if a jury decides we were wrong to cut their chains? We could lose our home." I did not have a good answer for that. The legal system was supposed to protect people from this kind of abuse, but Karen Whitmore had found every possible way to weaponize it against us. In March 2024, our case finally went to trial for the quiet title action. After months of delays and legal maneuvering, we were finally going to get our day in court. The trial was held in the same courtroom where we had won the restraining order, but this time it would be a full evidentiary hearing lasting several days. Natalie called me as the first witness. I testified about purchasing my property, the easement rights in my deed, and the years of peaceful use of Riverside Lane. Richard Stokes Cross examined me aggressively, trying to suggest that I had known the road might be claimed by the HOA and had purchased anyway. "Is it not true, Mr. Xavier, that the Sunset Ridge development was already in place when you bought your property in 2018? "Yes, but they are on the other side of the highway. Their development has nothing to do with Riverside Lane." "Did you physically inspect the boundaries of the Sunset Ridge HOA property before purchasing?" I looked at the plat maps on file with the county. Riverside Lane was not part of their development. "But did you physically walk the property boundaries?" "No, I relied on the official county records." "So you cannot say with absolute certainty that the property was not part of the HOA. The official records say with absolute certainty that it was not. That is what records are for." The exchange went on like that for hours. Stokes was trying to create doubt, to suggest that we had been negligent or willfully blind. But Natalie had prepared me well, and I stuck to the facts. Patricia testified next, explaining the discrepancies in the correction deed and the lack of any legitimate basis for the HOA's claim. Tom, Eugene, and the others all testified about their years of living on Riverside Lane and maintaining the road themselves. Then Natalie called Robert Finch from the county recorder's office. His testimony was damning. He explained in detail how the correction deed did not meet legal requirements, how he had flagged it as problematic, and how Gary Mitchell had overridden his objections without explanation. "In your professional opinion, was this correction deed properly filed?" Natalie asked. "No. It should have been rejected." "Why was it accepted?" "Because the elected county recorder ordered me to accept it." "Had you ever seen Gary Mitchell override your professional judgment before?" "Not in 20 years of working together. This was highly unusual." The HOA's case rested almost entirely on the correction deed. and the testimony of a surveyor they had hired who claimed that based on his interpretation of the original 2005 plat maps, Riverside Lane should have been included in the Sunset Ridge development. Natalie tore him apart on cross-examination, getting him to admit that his interpretation contradicted the actual legal descriptions in the recorded documents. On the third day of trial, Natalie called her surprise witness, Stephen Crawford, the retired attorney who had allegedly advised Karen about the correction deed. Crawford appeared via video conference from his home in Fort Myers, Florida. He looked tan and relaxed, sitting on a porch with palm trees visible in the background. "Mr. Crawford, did you advise Karen Whitmore or the Sunset Ridge HOA about filing a correction deed to claim Riverside Lane?" Natalie asked. "Absolutely not," Crawford said firmly. "I retired from my position as HOA counsel in 2020. I had no involvement with the association after that time." Miss Whitmore testified under oath that she filed the correction deed based on your legal advice. Was she telling the truth? She was not. "I never told her to do that, and if she had asked me, I would have told her it was illegal." Karen, sitting at the defense table, turned bright red. Stokes looked like he wanted to disappear through the floor. Judge Preston leaned forward. "Mr. Stokes, did your client commit perjury in this court?" Stokes stammered. "Your Honor, there may have been a misunderstanding or miscommunication." "There seems to be a great deal of misunderstanding in this case," Judge Preston said dryly, "most of it originating from your client. We will address the perjury issue separately. Please continue, Miss Griffin." The trial concluded the next day. Judge Preston took the matter under advisement and said he would issue a written ruling within 30 days. We left the courthouse exhausted but cautiously optimistic. "She lied under oath," Tom said as we stood in the parking lot. "That has to help us, right?" "It definitely does not help them," Natalie said. "But I do not want you to get overconfident. We still need the judge to make his ruling." The 30 days felt like an eternity. Every day I checked my email and the mail obsessively, waiting for news. The criminal investigations were still ongoing, but we had heard that Gary Mitchell had resigned as county recorder after the Attorney General's office threatened to file charges. Susan Mitchell had also returned the $25,000 to the HOA and claimed it had all been a misunderstanding. On April 15, 2024, Judge Preston issued his ruling. It was 38 pages long, and Natalie called me as soon as she received it. "We won," she said simply. "We won everything." I felt tears spring to my eyes. "Really?" The judge ruled that the correction deed was fraudulent and void. He found that Riverside Lane is not and has never been part of the Sunset Ridge HOA. He confirmed your easement rights and ordered the HOA to remove the gate and all barriers immediately. He also awarded us attorney's fees and costs. What about the counterclaims? Dismissed with prejudice. The judge was pretty harsh on the HOA. He said their counterclaims were filed in bad faith for the purpose of harassing the plaintiffs. Here, let me read you part of his ruling. She cleared her throat and read. "The evidence presented at trial demonstrates a disturbing pattern of behavior by the Sunset Ridge Homeowners Association and its president, Karen Whitmore. Rather than respecting property rights and legal boundaries, Miss Whitmore embarked on a scheme to fraudulently acquire property that did not belong to the HOA. She filed false documents with the county recorder's office, likely facilitated by improper payments to the recorder's wife. When her scheme was challenged, she used the HOA's resources to wage a campaign of harassment and intimidation against the rightful property owners. This court will not countenance such behavior. The plaintiffs are entitled to their property rights, their attorney's fees, and the peace of mind that should come with homeownership." I could not speak for a moment. Relief flooded through me so intensely that I had to sit down. "Derek, you still there?" Natalie asked. "Yeah," I managed. Thank you so much. You are welcome. But this is not quite over. The HOA has 30 days to appeal. I do not think they will, especially with the criminal investigations pending, but we need to be prepared." The next few weeks were tense. The HOA removed the gate, but slowly and with obvious reluctance. Karen Whitmore did not show her face on Riverside Lane, but we heard through the grapevine that she had been removed as HOA president by the board, and that the remaining board members were furious with her for exposing them to legal liability. In May 2024, the Arizona Attorney General filed criminal charges against both Karen Whitmore and Gary Mitchell. Karen was charged with filing false documents, fraud, and conspiracy to commit fraud. Gary was charged with corruption, bribery, and malfeasance in office. Both faced potential jail time. The deadline for the HOA to appeal came and went without any filing. Natalie sent us a letter confirming that the judgment was final. Riverside Lane was officially, unquestionably, permanently ours. The criminal cases moved slowly, as such things do. Gary Mitchell took a plea deal in August 2024, agreeing to plead guilty to corruption charges in exchange for avoiding jail time. He was sentenced to 5 years probation, 500 hours of community service, and permanently barred from holding public office. He also had to pay a $50,000 fine. Karen Whitmore was more defiant. She refused to take a plea deal and insisted on going to trial. Her criminal trial was held in November 2024, and I attended several days of testimony. Watching her face as the prosecution presented evidence of her fraud was satisfying in a way I had not expected. The jury deliberated for less than 3 hours before finding her guilty on all counts. At her sentencing in January 2025, the judge gave her 18 months in jail, 3 years probation, and ordered her to pay restitution to our neighborhood for our legal fees, which by that point totaled nearly $40,000 per household. Miss Whitmore, you abused your position of authority in your homeowners association to commit fraud and harassment against your neighbors, the judge said. You corrupted a public official and filed false documents with the intent to steal property that did not belong to you. Your actions have damaged public trust in both homeowners associations and county government. This sentence reflects the seriousness of your crimes. Karen was led away in handcuffs, still maintaining her innocence and shouting about how she was being persecuted. I felt no sympathy for her. She had tried to destroy our lives, and she had finally faced consequences for her actions. In February 2025, the Sunset Ridge HOA itself underwent major changes. The remaining board members were voted out, and new leadership took over with a mandate to reform the association's practices and rebuild trust with the surrounding community. They sent formal apologies to all of us on Riverside Lane, though by that point, the gesture felt hollow. The restitution payments started coming in monthly installments. It would take years for Karen to pay back what she owed us, but at least we were being compensated for the nightmare she had put us through. Life on Riverside Lane slowly returned to normal. We still maintained the road ourselves, splitting costs and responsibilities just as we always had. The experience had brought our little community closer together. We had barbecues in the summer, a block party at Christmas, and helped each other with yard work and home repairs. Tom Henderson joked that we should form our own HOA just to be ironic, but the rest of us shut that idea down immediately. We had seen what HOAs could become when the wrong people got power, and none of us wanted any part of it. In March 2025, almost exactly 2 years after Karen first put up that chain, Nina and I hosted a celebration dinner at our house for all the Riverside Lane families. We grilled steaks, opened expensive bottles of wine, and toasted to our victory. To property rights, Tom raised his glass. To good lawyers, Patricia added. To standing up to bullies, said Melissa Johnson. To peace and quiet, Eugene Kowalski said with a smile. We all drank to that. As I looked around at my neighbors, people who had become true friends through our shared ordeal, I felt grateful. Grateful that we had fought instead of giving up. Grateful that the legal system had ultimately worked, even if it had taken time and money and stress. Grateful that justice had prevailed. I never saw Karen Whitmore again after her sentencing. I heard she was released from jail in July 2025 after serving her full sentence. She moved out of state, and someone told me she was living with family in Nevada. The house she had owned in Sunset Ridge was sold to cover her debts. The gate at the entrance to Riverside Lane was completely removed in June 2025, and we had a small ceremony when the last piece of it was hauled away. We planted a tree in its place, a young oak that would eventually provide shade and beauty instead of representing barriers and conflict. On quiet evenings, I sometimes walked down Riverside Lane and thought about everything that had happened. The street looked the same as it always had, lined with oak trees and well-maintained homes. But I knew that beneath the surface, we had all changed. We had learned that property rights matter, that official documents can be manipulated, and that sometimes you have to fight for what is rightfully yours. We had also learned that community matters. If we had faced Karen Whitmore individually, she might have won. But together, we had the resources and the determination to stand up to her fraud and see it through to the end. Most importantly, we had learned that accountability matters. Karen had thought she could abuse her power without consequences. Gary Mitchell had thought his position as an elected official made him untouchable. They were both wrong, and they both paid a heavy price for their corruption. As I walked back to my house that evening, the sun setting over the Arizona desert in brilliant shades of orange and pink, I felt at peace. Riverside Lane was ours. It had always been ours, and now everyone knew it. The county recorder's office implemented new policies after the scandal, requiring all correction deeds to undergo enhanced review and mandating that any county official with potential conflicts of interest recuse themselves from related decisions. Robert Finch was promoted to county recorder in a special election and implemented reforms that made the office more transparent and accountable. The Sunset Ridge HOA became a cautionary tale in Cedar Springs and throughout Maricopa County. Local news covered the story extensively, and it sparked a broader conversation about HOA accountability and the need for oversight of these private organizations that wielded significant power over homeowners. Several state legislators proposed bills to increase regulation of HOAs and to create stronger penalties for fraud and abuse of power. I even testified before a state committee about our experience, hoping that our nightmare might prevent others from going through the same thing. By the fall of 2025, things had truly returned to normal. The legal bills were paid, the restitution was coming in regularly, and our property values had recovered. New families moved into the neighborhood, and we always made sure to tell them the story of Riverside Lane so they would understand the importance of protecting their property rights. Tom Henderson started a neighborhood watch group, not because we had crime problems, but because we all felt more vigilant now about protecting our community. Patricia Chen became active in local government, attending city council meetings and staying informed about development issues that might affect our area. As for me, I went back to my quiet life as an IT consultant, but with a new appreciation for the power of property deeds, county records, and the legal system. I also had a much lower tolerance for anyone who tried to abuse authority or manipulate official documents. Nina and I celebrated our 10th wedding anniversary in December 2025, and we talked about the past few years over dinner at our favorite restaurant in downtown Cedar Springs. "Would you do it again?" she asked me. "If you could go back to that morning when you found the chain, would you still fight it?" I thought about that for a moment. "Yes," I said finally, "because if we had not fought, we would have lost our home, and Karen would have gotten away with fraud. Someone had to stand up to her." "I am proud of you," Nina said, reaching across the table to take my hand. "It was hard and it was expensive and it was stressful, but you did the right thing." As 2026 began, I found myself reflecting on lessons learned. The experience had taught me that homeownership comes with responsibilities beyond just paying your mortgage and mowing your lawn. It means understanding your property rights, knowing what is in your deed, and being willing to defend those rights when they are threatened. It had also taught me about the importance of community and solidarity. None of us could have fought Karen Whitmore alone, but together we were strong enough to prevail. That lesson extended beyond property disputes. In any conflict, finding allies and building coalitions makes all the difference. Most of all, the experience had taught me to never assume that authority figures are acting in good faith, or that official documents are accurate, just because they are filed with the government. Karen and Gary had exploited the trust people place in the system, and it had taken almost 2 years of fighting to expose their fraud. In February 2026, exactly 3 years after Karen first put up the chain, Patricia organized a neighborhood commemoration. We gathered at the spot where the gate had once stood, now marked by the oak tree we had planted. Each family shared their thoughts about what we had been through and what it meant to them. Dorothy Kowalski spoke about how terrified she and Eugene had been, worried they would lose their retirement home. "But we did not give up," she said, her voice stronger than I had heard it in years. "We stood together and we won." Melissa Johnson talked about protecting her young family and making sure her daughters grew up in a place where property rights were respected. "I want them to learn that you have to fight for what is right, even when it is hard." Tom Henderson raised a glass of champagne. "To Riverside Lane," he said. "May we always remember what we fought for, and may we never take our freedom for granted." We all drank to that, standing together on the road that was truly, finally, unquestionably ours. As the gathering broke up and everyone headed home, I stood for a moment longer, looking down the length of Riverside Lane. The oak trees swayed gently in the evening breeze. Lights glowed warm in the windows of our homes. Children played in yards. Dogs barked. Life went on, peaceful and normal. But I would never forget the battle we had fought here. The fraudulent deeds and the locked gates and the legal motions and the testimony and the waiting and the worrying. It had tested all of us, pushed us to our limits, cost us money and time and peace of mind, and in the end, we had won. Not because we were lucky or because Karen Whitmore made mistakes, though both of those things were true. We had won because we refused to give up, because we stood together, and because ultimately the legal system worked the way it was supposed to work, even if it took longer than we would have liked. As I walked back to my house, where Nina was waiting with hot cocoa and a fire in the fireplace, I felt a deep sense of satisfaction. Riverside Lane was home. It had been home for 8 years, through good times and bad. And now, after everything we had been through, it would be home for many years to come. The story of our battle with the Sunset Ridge HOA became part of the history of our street, a story we would tell to new neighbors and eventually to our own children. It was a story about standing up to bullies, about the importance of property rights, and about what happens when people abuse power and think they are above the law. But most of all, it was a story about victory, about justice prevailing, about a community coming together to fight for what was right and winning against all odds. And that, I thought as I opened my front door and stepped into the warmth of my home, was a story worth telling.